Now, one of the other suggestions that you have made is that giving the Lord President formal status as the head of the Scottish Judiciary will add significantly to the burdens of that office and will transform the Lord President into a super administrator. You would have heard what Lord Hamilton had to say last week, and reassured by his evidence that he envisages that the substantial amount of his time, a majority of his time, will be spent doing what Lord Presidents, to my mind, should be doing, presiding over the appeal court.
In my lifetime, the Lord President invariably remained in office as Lord President until he retired. However, the burden of administration, even of the existing system, became such that Lord President Hope, followed by Lord President Roger, both departed as quickly as they could to London in order to write judgments on matters of law, rather than to administer everything from the colour of the lavatory paper to the frequency with which the windows were cleaned in the Parliament House, which is the kind of thing they had to regulate on. I advocated publicly, without success until quite recently, that there should be appointed a chief administrative judge. I've seen examples of it in America and Australia and other countries in the world, and that's now been done. But what is happening is the burden, the judges are not good administrators. A judge is an advocate most of his life, hitherto. He administers his fee book and his die, and nothing else. He has no staff. He operates through a limited company, the Faculty Services Limited. So my experience of administration was very, very small, similarly with the Lord President. And I think that the burden being put upon him requires him, therefore, to engage large numbers of civil servants to do his bidding. And I don't approve of that. I don't approve of the growth of the civil service, which has been massive in my time, especially in, for example, the Crown Office. When I started in the Crown Office, there were about 4 civil servants. Now there must be 80.
Can you perhaps tell us, when was the administrative judge appointed?
I don't know. It was not done when I retired in 2004. But reading the evidence of the Lord President, I understand there is one, so I don't know. But I advocated it for many years, and in fact I advocated it in my responses in 2006 to the original paper, so it must have been done, I think, since then.
My point in raising that is that, to some extent, I share your concerns, which is why I questioned the Lord President on these lines quite thoroughly last week, and he was content. It may well be that the appointment of the administrative judge has greatly alleviated the administrative pressures on the post holder of Lord President.
Well, it may have done, Convener, but it also then makes another judge devote more time to administration, and that's what's happening. Now, in my time, a number of judges retired early because they went on the bench to do what they've been doing all their lives, to consider the development and application of the law to particular cases. And they found themselves moved more and more towards criminal business. And nowadays, I think the judges spend about 3 sitting days out of 4 wearing criminal robes, doing criminal business either on appeal or in trial cases. So the amount of time they spend on developing the law is tiny, if it's a quarter, I'd be surprised. And furthermore, if they're going to be given admin burdens as well, and this bill is full of them, then I'm afraid it's going to make people disenchanted. Already we are seeing a situation in which the best people are sometimes not applying to go on the bench.